Until 1858, abortion in America had been relatively simple. If a woman wanted an abortion, all she had to do was say she hadn't felt any movement in her womb. These were considered pre-quickening abortions, which were allowed. And being that the only person who could tell you if a woman had felt movement in her womb was the woman herself, abortion prosecutions were incredibly rare. This was complicated a bit after 1821, when a few states enacted laws against giving noxious substances to women for the purposes of abortion. But generally, a woman who wanted an abortion could get one without worry of prosecution. Then, in 1858, the American Medical Association got involved. Physicians in the 1850s suffered from poor reputations. It seemed to many that they either couldn't help you at all, or their advised treatment plan was simply a way of avoiding future suffering by bringing closer your appointment with death. This led to people seeking treatment with homeopathists, midwives, and other medical practitioners who, although sometimes just as ineffective as physicians, made more optimistic promises. Physicians weren't happy about this. For decades, they had tried to get legislation passed which would forbid non-physicians from practicing medicine. Doing so would secure them a monopoly on medical care, ensuring any money paid out for treatment would end up in their pockets. But their attempts to change the laws largely failed. Then, in 1858, the gynecologist Horatio Robinson Storer decided he could change this and boost the reputations of physicians by targeting a procedure which physicians often refused to carry out on account of the Hippocratic Oath: abortions. To begin with, he went about convincing fellow physicians that they should campaign for the criminalization of abortion. He argued that life began at conception rather than the quickening, and pointed out that money paid for abortions was not going to line their pockets. There was minimal resistance to Storer's arguments from fellow physicians. When a writer from the Boston Medical and Surgical Journal pointed out that Storer seemed to have thrown out of consideration the life of the mother, a backlash from other medical journals caused a recantation and the publication of a glowing approval for Storer's ideas. With the physicians of the American Medical Association now on his side, presumably with dollar signs flashing in their eyes, Storer and the rest of the AMA brought their crusade to the public. But the arguments he had used to convince fellow physicians were no longer so useful. The public was hardly going to be convinced that abortion was a moral evil because women who obtained them failed to line the pockets of the AMA's physicians. So, a different strategy was employed: racism. Race worked a little differently in the 1850s. Black people were certainly targeted by racism, but there were other racial categories which have since faded from existence. The Irish, for example, were considered Celtic, and thus supposedly racially inferior to native Anglo-Saxon Americans. Their Catholicism also caused many to put their allegiance into question. Playing on these fears, physicians claimed that vain and fashionable Anglo-Saxon women were having only half the number of children of Celtic women, as they, unlike the Irish, sought abortions rather than fulfilling their supposed natural roles as mothers. The outcome of this, they argued, would be their outnumbering, outvoting, and eventual domination of the Anglo-Saxon race by the Irish Celts. This, of course, would result in the collapse of American society as the USA was replaced by a theocratic state headed by the Pope. To avoid this future, there was only one possible solution: criminalize abortion, with exceptions in certain cases authorized by the agreement of two registered physicians, thus assuring physicians were the only ones who could profit from future abortions. These arguments were a great success. Between 1860 and 1880, more than 40 anti-abortion statutes were written into state and territorial law codes. In 1860, Connecticut enacted a law which made abortion a felony, punishable by up to 5 years in prison and a $1,000 fine. Pennsylvania's 1860 law made any attempted abortion an offense, whether the woman was pregnant or not. And in 1872, New York made it illegal to perform an abortion with a sentence of 4 to 20 years in prison for those who did. By 1900, abortion was a felony in every state, with some states allowing for exceptions to save the woman's life, but only by the agreement of two physicians. Women who had long been free to have an abortion before the self-reported quickening suddenly found themselves forced to remain pregnant by the state, largely because of the greed of the physicians of the AMA and the racism of 19th century American society. It will surprise few people that this did not stop abortions from happening. By the 1930s, licensed physicians were performing around 800,000 abortions a year, not accounting for illegal abortions, which led to the deaths of at least 2,700 women that decade. This with a population of just 123 million. Whereas, according to the CDC abortion surveillance system, 2017 only saw 612,000 US abortions in a country with a population of 325 million. In the 1950s and 60s, the deaths attributed to illegal abortions, including photos of the aftermath of women who had died to them, led to a push for significant abortion reform, culminating in the 1973 Roe v. Wade decision, which guaranteed abortion rights to women without excessive government restriction. Since Roe, abortion mortality levels have taken a dive, as have the number of abortions themselves. But if the reversal of Roe v. Wade that appeared in a leaked draft opinion from the Supreme Court on the 2nd of May goes through, the inevitable increase in unsafe abortions that follows could see a return to the increased abortions and mortality of the 1960s and before.